Um, Do you want to proceed with the reading of the indictment?
No, Your Honor. We'll acknowledge receipt of the indictment. We will waive reading and any defects of service.
Okay. What about the potential penalties? Do you want to?
We'll waive reading of that.
You'll waive reading of that as
Yes.
well?
I've had a
Okay.
chance to talk to him about that.
All right. Mr. Hardman, anything on
The
that?
state of Ohio respectfully requests the court to issue a bond of $1 million in light of the charges that are pending before the defendant that carry the possibility of life without parole 4 times over with regard to rapes of a child who was 5 years old that was in the care of the defendant, as well as that defendant's mother, who was the co-defendant in this case. We would also ask that if the defendant does make that bond, that he be placed on electronic monitored house arrest. Furthermore, that he be ordered not to have any contact with minor children and animals, and that the defendant, that there be a protection order issued as it relates to a minor child who is named in this particular charges in these indictments.
All right, thank you. You want to be heard on bond?
Yes, Your Honor. And I also, before we leave, I do have a couple of oral motions as well I'd like to.
Okay.
But as to bond, Your Honor, my client, obviously, I just learned about the case. I know nothing about the underlying facts of the case. I know the court doesn't know anything about the underlying facts of the case either. He does have a place to live. He is on Social Security disability. He has no real record to talk about. I think we even saw in his record a fishing violation, and that's kind of the extent of his run-ins with the law. I think it, Your Honor, would be appropriate to release him on his own recognizance with electronic monitoring. He could turn over his passport. He does not appear to be a flight risk in any way, especially with electronic monitoring and his ties to the community. So that would be what I would suggest as an appropriate bond.
All right, thank you.
In terms of, I do one other thing. In terms of the no contact order, we have no problem with any no contact order, except that he does have a 16-year-old daughter with the initials CM, who is, I'm told, I believe, not a witness in the case, and therefore we'd ask that he be allowed to have contact with his 16-year-old daughter.
Does she live with him?
50-50.
I think he's indicating 50-50
Split.
joint custody.
Okay. All right, any response from the state?
Yeah, we would ask that he remain away even from that child. When we are dealing with a child that he had very regular contact with, that there is very strong evidence that indicates he was involved, if not the actual touching, but in participating in allowing that activity to happen with regard to that 5-year-old child. And so any contact, we believe, with a minor child would not be appropriate if you want to make a bond in our position.
All right. All right, the bond is $250,000, 10%. No contact with the minor child. Victim in this case, a temporary protection order will be issued with regard to the 16-year-old daughter. Generally, children 16 years of age are permitted to choose which parent they live with. I know this is not very far from a typical situation where this decision is being made. Does he get along with the mother of the child?
Yes, very well.
Okay, then as long as she's in the supervision of the mother during any time he sees his daughter.
Yeah. And the court would be okay with electronic contact as well, like phone calls.
Oh, yes.
Okay.
Also, if he makes bond, he's on electronically monitored supervision with a curfew of 10 p.m. until 6 a.m. Anything else from the state?
No, Your Honor.
Let's talk about speedy trial issues.
Yes.
Do you, I don't know what your motions are yet, but if you feel that there's going to be a problem making bond, then we're going to have to move on this case.
Yeah, what I'd suggest is we set it for a pretrial within a couple weeks, and we can
Okay.
figure out, we'll request discovery within the next day or so, and hopefully we'll get that soon, and we'll be able to have a meaningful pretrial in the next couple weeks.
Okay, and you wanted to address a
Yeah,
couple
if I can
motions.
approach you. So, two motions that I'd like to make right now. Apologize, I wasn't able to file anything earlier since I wasn't technically on the case. One is an easy one and one is a hard one. The easy one is we have just submitted a motion for the preservation of evidence. By filing this motion, I'm just merely protecting the rights of my client. I know with some 12th District law that if we don't file a motion to preserve some of the evidence, like videotapes, I don't know if there's audio recordings of victims or anything like that. We just want to make sure they're preserved. Nothing with this prosecutor's office. This prosecutor's office is very good. I have no reason to suspect that anything's going to disappear. I just have another case going on in another county where some videotapes of victim statements have disappeared. So I'm just doing that to protect the record here.
Okay.
The other motion, however, is a motion to limit pretrial publicity, and I've submitted a proposed order for the court that is cut and pasted from the DOJ manual. And so we're asking the court to impose precisely the type of restrictions that the Department of Justice imposes on its own attorneys in criminal cases. I've been very disturbed just when I found out that I was going to be asked to work on this case about some of the pretrial statements that have been made by the prosecutor's office. I feel they have a substantial likelihood of prejudicing the jury pool in this case, and so we'd ask the court to limit what the prosecutor can say to what is normally said by the Department of Justice in these types of cases about the charges, to emphasize that the defendant is innocent until proven guilty, and to not make any statements that will interfere with his right to a fair trial.
Have you provided a copy to the state?
Yes, I have, Your Honor.
Any response from the state on these two motions?
Your Honor, with regard to the motion to preserve evidence, we have no objection to that. We are obviously understand our obligations to preserve such evidence and would continue to do so. With regard, I have not seen a motion as it relates to the pretrial publicity. I've only seen a submitted entry. That has given us absolutely no opportunity to respond with appropriate information. We fully believe that any statements our office has made comply with ethical guidelines as well as what is required of us to maintain our ability to prosecute a case. I think entering any kind of orders based on Department of Justice guidelines, whether they are or not, we don't know at this point, would be inappropriate. I've had absolutely no time to look at what the attempts are to gag the state with regard to anything it says to media inquiries as it revolves around this particular case. And I think at this point, without us having the opportunity to examine further this entry and this suggested motion, it would be inappropriate to enter it at this time.
Okay, I'll give the state 48 hours. What is today? Wednesday. Respond by 4 p.m. on Friday to his, I guess, anticipated motion. It's an oral motion at this point.